Hello, everyone. As David said, I'm General Counsel for Cedrus Investments, and prior to that, I've been at Cedrus for 8 or 9 years now. But prior to that, I was in private practice as an employment litigator, representing both employees and employers in wrongful discharge and related types of suits. Over that 2 decades, I learned quite a few things about what employers and managers should do that and they weren't doing, and so I'm hoping to pass along some of those lessons to you today. As a manager and as a or as a business owner, firing employees is a necessary function, and if you're in business long enough, you're going to end up doing it. However, this termination of an employee carries with it a special risk. Employees can and will often bring claims of wrongful discharge based on a variety of potential allegations, including discrimination, retaliation, wage and hour liability, defamation, and so forth. The list seems to grow every year. As some cases, which I'll discuss, have demonstrated, the ramifications of these claims can affect a business for years. That's because of the business's exposure to potential damages. Those potential damages can include back pay. Back pay is defined as the amount of money the employee would have earned had they not been terminated, the amount of compensation they would have earned from the date of termination to the date of trial. That amount of compensation also includes whatever benefits, collateral benefits that they would have been entitled to. Then there's the issue of front pay. Front pay is the amount of money from the date of trial forward to some date in the future. As a plaintiff's attorney, I would ask for that point in the future to be date of retirement. So if you have an employee who's, say, 30, 35 years old, that amount of front pay can be 25 or more years worth of compensation. That can add up fairly quickly. As a defense lawyer, my response to that would be that generally the employees for our company didn't last that long. They were 2 or 3 years, and we should use that as a standard basis for calculating the front pay damages. Whatever the court decides, it can still add up to a substantial amount of money. Then there's the issue of punitive damages. If the termination is construed or is done maliciously, as in the case of a retaliation or discrimination, the company can be liable for punitive damages. And those are calculated to punish the employer or the company. And that is usually based upon revenues over a particular period of time that the court looks at and says, well, sometimes they want you to disgorge profits over a period of time. Sometimes it is an amount of money that is designed to teach the company or the employer a lesson about this particular practice, which resulted in the termination of that employee. Then, of course, is my favorite, which is attorney's fees and costs. The company or the employer can be liable for not only its own attorney's fees and costs, but the employees, the successful employees' attorney's fees and costs. That doesn't, and your liability won't end there. There's regulatory fines and costs. There's also lost business opportunities. The list can go on. So these kind of terminations can be significantly harmful to the company or to the employer, and so you need to know how to prep things so that your termination is as bulletproof as possible. All of that to say that the question of whether to terminate an employee is a primarily business decision, so long as the termination is not done for reasons that are illegal under state or federal law. Whether that termination is construed to be a violation of the law can also be a difficult question because the sources of legal liability can be found in a vast number of laws, some of which are completely unrelated to the employer-employee relationship. The scope of what I'm going to talk about today is not designed to immunize you from lawsuits or claims, but by taking the measures we discuss here, you'll learn that you can help discourage such claims and assist in prevailing on them when and if the case reaches litigation. However, the foundation for reducing the risk that terminations can bring has to be laid long before the termination is done. One of the biggest errors that I've noted in my practice is that employers often fail to make or plan ahead so that these types of terminations are as bulletproof as possible. So we're going to talk a lot about how to plan out your policies, your procedures, and so forth in order to successfully do these types of terminations. This presentation is going to be based primarily on U.S. and California law. In California, we have both state and federal laws that govern the employment relationship. Some states follow only federal laws, and others will have both a state and federal regime. Whatever your state, wherever you happen to be, you need to be aware of both the state and the federal laws that govern your company. And if your company has multiple jurisdictions, multiple locations, such as my company does, you need to be aware that the local laws will apply to the offices and areas where you happen to have your business locations. So, example, my company has offices in the UK and Asia, and the employment laws in those areas are substantially different. And depending on where you are, the principles will be the same, but the procedures will be different. So just bear in mind that you need to know where your offices are located and where those terminations are being done. Okay, so what are we going to learn today? Types of employees. Types of employees meaning, is the employee at will? Are they employed under a contract? Is the contract a individual contract or a collective, like a union contract? Or is the employee a government employee? All of those make a significant difference. Designing and implementing employment termination policies. This is the nitty-gritty. This is where you actually are going to lay out the policies that govern your organization and govern how you do your terminations. Risk analysis. Doing a risk analysis prior to the termination is going to be important, and you need to know whether you have everything necessary to support the termination decision, and we're going to talk about what those elements are. Layoffs and discharges. Are you doing a layoff, a reduction in force, or are you discharging for cause? There is a difference, and it doesn't really matter what you call it, because ultimately, if it becomes a matter of dispute, you're going to have to prove that it is one or the other. When is it illegal to fire an employee? Well, each state and the federal government has specific laws designed to say you cannot terminate on this basis or that basis. Some of those laws are not going to be in obvious places, and I will tell you where you can find some of them, but broadly speaking, you need to be familiar with the laws that govern your organization. Documenting performance. Along with your employment termination, the policies, documenting performance is really part of your planning stage. So where you have a situation that uh, where you have a policy that says you can terminate under these situations, you need to document that situation has um, occurred and that you're justified in terminating this employee. Conducting a legal review. There are things you should know, and we're going to talk about that. Informing the employee. The final uh, steps in the process of terminating the employee include a final meeting with the employee to lay out what is the basis of the termination and so forth. And we're going to talk about what to say and what not to say and how to do that. I'm going to talk about severance pay because that can be a good tool for you to use to avoid liability. And finally, the termination checklist. The termination checklist will also include the post-termination checklist of things to do and not to do. So those are the things